Winning an injury case can be difficult. Insurance adjusters will tell you that you should take a low settlement now because you have no shot at winning much in your case. I've seen this time and time again. You see, I spent years working on behalf of insurance companies defending personal injury claims in court. To win an injury case, you will need the necessary evidence to prove liability against another party. Let me tell you the story of my past client, Naomi. Naomi was struck by a vehicle when she was a pedestrian. But what I'm about to teach in this video will apply to any type of injury case, including automobile accidents, slip and trip and fall incidents, and any other type of injury case. During my first conversation with Naomi, she told me there was probably nothing I could do for her, as she was likely at fault for the accident. She only called because she wanted to make sure that she absolutely did not have a case. Naomi admitted that she had drank some alcoholic beverages the night of the incident, shortly before the incident had occurred. She also admitted that she was in an argument with a family member when the incident happened. She recalled very few other details about the incident. She did not know if she had the right of way because she did not know if the crosswalk light was signaling to her that it was safe for her to cross the street in the crosswalk. She did recall being in an argument with her family member who was on the sidewalk she was departing, and that she was crossing at an intersection on or at least near the crosswalk. She admitted to me that she was caught up in the argument and not really paying attention if it was safe to cross. She remembered making it a little bit across the street when she was suddenly struck by a vehicle. Her injuries were significant. Naomi was lucky to still be alive. As a result of her incident, Naomi suffered fractures in both knees, along with a fracture and partial tear in her right shoulder. She also incurred lacerations to her head, knees, and hands, among other injuries. I felt awful for Naomi. There seemed to be a good chance I was not going to be able to help Naomi at all. But she was such a nice person, I decided to take on her case to see if I could possibly help her out. I told Naomi to focus on her medical treatment while I found out everything I possibly could about her accident by investigating how it happened. My team and I immediately began investigating her case after Naomi became a client. We contacted all the businesses with offices near the intersection of where Naomi's incident occurred to see if they had any surveillance footage that caught the incident on video. Fortunately, we were able to track down 2 separate videos depicting Naomi's incident on video. It was crucial we'll be able to prove at least some liability against the driver of the vehicle that struck Naomi if we had a chance of recovering any money for Naomi. If we could not prove any careless behavior by the driver in causing the accident, Naomi would get nothing. I remember watching the surveillance videos which depicted Naomi's accident from 2 different angles. Several things stood out from me after I watched both videos. 1, Naomi had clearly been in the intersection for some time before being struck by the driver, having even almost cleared the driver's lane of travel. 2, the impact flipped Naomi into the air. 3, despite Naomi being clearly in the intersection, it was obvious the driver did not slam on his brakes until he struck Naomi's body. I was able to tell this because his brake lights did not illuminate until after his vehicle impacted Naomi's body. 4, after slamming on his brakes, despite traveling at least 25 miles per hour, he was able to bring his vehicle to a complete stop mere feet after slamming on his brakes. 5, Naomi was well in the intersection and in the driver's lane of travel before he even entered the intersection. 6, the driver's light turned yellow as he entered the intersection. Instead of using caution, he struck Naomi, flipping her body into the air, a very scary incident. These videos were all I needed to piece together an argument that the driver shared some liability for this accident. It was clear I now had some arguments that the driver was at least partially at fault for this incident. And per the law in Kentucky, that is good enough, since Kentucky is what is known as a pure comparative negligence state, where if you can show that another party is at least partially at fault for the accident, you are entitled to at least partial compensation for your damages from that party. For example, in Naomi's case, if we could show the other driver was 50% at fault, Naomi would thus be entitled to 50% of her damages against the driver. I argued that despite Naomi clearly being in the intersection, the driver must not have been paying much attention to the roadway at all, or he would have been able to slam on his brakes and stop well before striking Naomi. While Naomi should not have been crossing the street at that exact time, the driver still should have been using caution and seen her with plenty of time to brake before striking her body. These were the arguments I made to the insurance company, but I knew deep down that if Naomi's worst day in court came true, she could get nothing for her claim. This was in the back of my mind before we began settlement negotiations with the driver's insurance company. Naomi wrapped up her medical treatment after a few months of medical treatment. My office then gathered all of Naomi's medical records and bills. I sent a written demand to the driver's insurance company to kick off settlement negotiations. And after several rounds of negotiations, we ended up settling Naomi's case for $75,000. If we could have proven the driver was 100% at fault for the accident, we certainly could have gotten Naomi more money. But on a good day in court, if the case had to go to a jury trial, we estimated we would only be getting maybe 50% of her damages against the other driver. So Naomi decided to take the $75,000 settlement rather than risking it and possibly getting zero if we took her case to court. This was a win. It was certainly better than getting zero for her claim. When Naomi first called me, she had almost no hope we would be able to get any compensation for her. She was going through a very difficult time and she was feeling hopeless. But we refused to give up on her case until we knew all the facts that we could possibly find out about her accident. We tracked down the surveillance footage after contacting several nearby companies. Without the surveillance footage, I do not think we get much, if any, compensation for Naomi. Certainly not the $75,000 we were able to obtain for her. If you have been involved in an accident and are not sure if you would be able to make a financial recovery on your case because you are not entirely sure if you were at fault or another party is, you need to do more digging. Investigate your case further. Track down surveillance footage. Track down witnesses to see what they say about the accident. Take photos of the accident scene or go to the scene of your accident and take photos. Even if it's a day or two after your accident, it's better than not taking any photos at all. Just because you initially think your case is not winnable does not mean your case is in fact unwinnable. Despite Naomi initially thinking she had no chance of getting any compensation in her injury case, Naomi's case ended up being winnable after all. The thing is, just because you have now discovered evidence suggesting another party is at least partially at fault for your accident, it does not mean the insurance company will just roll over and offer you a fair and reasonable settlement to resolve your case. You see, it is often the case that you must prepare to take your injury case to trial. And in this video about to pop up here, I'll tell you why preparing to take your injury case the distance can oftentimes get you a fair settlement offer in your case. Lastly, if you've been injured in a car accident, slip or trip and fall incident, or dog attack incident in Kentucky, remember to don't wait, call Tate.